today. Professor Christoph Schreuer really needs no introduction, but as a matter of our BCLP protocol, I will go through a very, very abbreviated biographical sketch. Professor Schreuer is a graduate of the universities of Cambridge, Yale, and Vienna. Over an academic career spanning more than 50 years, he has published numerous articles and several books in the field of international law. He has covered such diverse areas as human rights, adjudication by national and international courts and tribunals, sovereign immunity, the law of international organizations, the sources of international law, and the future of sovereignty. Since 1992, he has concentrated on international investment law and has written many articles on the subject. The main product of this activity is a 2-volume commentary on the Convention on the Settlement of Investment Disputes between States and Nationals of Other States, now in its 3rd edition. Of course, all of you know that this is a must-go-to referential work. He has written expert opinions in many investment cases and has served as arbitrator in ICSID and UNCITRAL cases. He has spent much of his academic career at the Department of International Law at the University of Salzburg in Austria, of course. From 1992 to 2000, he was elected Edward B. Burling Professor of International Law and Organization at the Paul H. Nitz School of Advanced International Studies of the Johns Hopkins University in Washington, D.C. From 2000 to 2009, he was Professor of International Law at the University of Vienna in Austria. Since March 2015, he is of counsel with the law firm of Zeiler in Vienna. He is currently working as an independent expert in investment cases. And without further ado, Professor Schreuer, again, on behalf of the firm, all watching, and certainly personally, thank you so much for joining us today. The floor is yours, sir.
Well, thank you for inviting me to speak in this series. I'm most honored by your invitation. The topic that I'm going to speak about today is investment arbitration. And this has attracted quite a bit of controversy over the years. The public debate about investment arbitration often proceeds from the assumption that it operates exclusively in the interest of big business. It is said that through these extraneous private courts, states lose part of their regulatory power, which otherwise they could exercise for the public good. Now, the logic behind these arguments is remarkable in several aspects. Why would states subscribe to such a bad deal? After all, it is states that enter into bilateral and multilateral treaties that provide for arbitration with foreign investors. States have concluded these treaties for more than 50 years. The vast majority of states have done so. States of all kinds and political complexions in all parts of the world have done so, developing, market-oriented, centrally planned, whatever. One explanation that we sometimes hear is that this is all a capitalist conspiracy. Under that theory, weak host states are coerced into these treaties by industrialized states, which in turn are willingly manipulated by multinational corporations. But the old North-South paradigm of rich capital exporting countries versus poor host states no longer holds true. Investment treaties have been concluded increasingly between developing countries. In fact, there are several hundred of such South-South bits. Also, increasingly, investors from developing countries do business in Europe and North America. A growing number of investment claims are directed against industrialized states. Therefore, the model of post-colonial imperialism looks less and less persuasive. An unquestioned premise of opponents of investment arbitration is that states exercise their powers in the public interest. The assumption is that if only states are left alone, they would do the right thing for the public good. This confidence in the benevolence and infallibility of the state is surprising. It is quite at odds with public perceptions in other fields. There is widespread agreement that we need judicial control of government action through administrative and constitutional courts. There's also much support for the idea that international human rights standards provide a necessary check on the abuse of powers by states, and that these standards must be supervised by international human rights bodies. One of the prime tasks of investment tribunals is to determine whether a particular state action is actually for the public good. The existence or non-existence of a genuine public interest is a central criterion for investment tribunals in many contexts. When it comes to investor protection, published opinion instinctively adopts a good state, bad investor scenario. So much so that the legitimacy of state action is automatically assumed. The mere existence of a mechanism that examines whether state action was in fact legitimate and in the public interest is regarded as unacceptable. Many commentators also take it for granted that foreign investors neither deserve nor need special protection. Why should they enjoy privileges? Why don't they just go to domestic courts like everyone else? If they really have a serious grievance, why don't they turn to their home states, which can raise their grievances on the diplomatic level? Let me briefly comment on these arguments from three perspectives. One is the investor's perspective, who seeks protection. Two is the host state's perspective, which seeks economic benefits from the investment. And third is a community perspective with its interest in the avoidance of international conflicts. So let me start with the question, do investors really need special protection? At first sight, investment treaties appear very one-sided. They offer guarantees only to foreign investors, but not to the host state. They impose duties upon the host state, but usually, at least the classical ones, not upon the investors. In reality, this seeming unfairness is designed to offset an imbalance that exists against the investor in the first place. Most countries, developing or developed, try to attract investments. They woo prospective foreign investors with promises and favors. However, once the investment is in place, the balance of power and interest changes fundamentally. The investor is subject to the host state's regulatory framework and to some extent to the whims of its bureaucracy. The regime in the host states may change, and with it, the country's political orientation. A regulatory framework that may have looked attractive initially may change and turn against the investor. Procedurally, the situation is no better. In many, if not most situations, domestic remedies in host states offer insufficient protection to foreign investors. Even if foreign investors have access to the local judiciary, the chances of obtaining justice before the host state's court are often slim. Not surprisingly, the confidence of investors in the host state's domestic courts is low. There are a number of reasons for that. Let me summarize those in 10 points. First, in many countries, there is no judiciary that is independent of the ruling regime. Would you want to obtain justice before the courts of North Korea or Russia against the state? Second, in some countries, the courts are notoriously corrupt. In fact, representatives of these countries sometimes even admit that. In Meerapfel versus Central African Republic, the respondent's representative admitted quite openly before the tribunal, our courts lack integrity and transparency. So there's no secret about that. Third, in other countries, courts often identify with local interest and often offer little comfort to foreign claimants. A good example is Deutsche Bank versus Sri Lanka, where the Supreme Court of Sri Lanka admitted quite openly that it was deciding against the foreign investor for the benefit of the local economy. Fourth, yet another problem is the extreme inefficiency of courts in many countries, leading to endless delays. In White Industries versus India, the Indian courts were unable to render a decision on jurisdiction in 9 years. Statistics from Argentina demonstrate that first instance decisions there take 6 years on average. But the case law of the European Court of Human Rights suggests that delays in rendering judgments is also a recurrent problem in some countries of Europe, and that I'm ashamed to say includes my own, namely Austria. In addition, courts are by no means always in control of investment disputes. Where local legislation is the source of the interference, the courts are usually powerless. In the Italian bondholders' cases against Argentina, the tribunals found that there was clear legislation in Argentina against the foreign investors. Therefore, it was futile to send the claimants to local courts, even for a limited period of time. 6, under many legal systems, the handling of investment disputes is in the hands of administrative bodies and not of courts. 7th, under some constitutions, you cannot enforce rights arising from treaties through the courts unless these treaties have been incorporated into domestic law through legislation. This is the case in countries that follow the British constitutional model. And of course, as we all know, there are many of those. 8th, another recurrent phenomenon is the powerlessness of courts in the face of a recalcitrant state administration. For instance, in SIAC versus Egypt, the investor prevailed 8 times before the Egyptian courts, but the executive simply refused to comply with the court decisions. Point 9 is that some cases involve a denial of justice or other wrongdoing by the host state's courts themselves, where the investor complains that it has suffered damage at the hands of the courts. It is not useful to refer the investor to these same domestic courts. In Saipem versus Bangladesh, for instance, the complaint was that the Bangladeshi courts had set aside an arbitral award that was unfavorable to a local state-owned enterprise for no good reasons. And finally, international enforcement of foreign and international arbitral awards is reasonably effective under the New York Convention and under the ICSID Convention. But the enforcement of foreign judgments is often impossible. Against this background, it is understandable that one of the chief motives for the introduction of investment arbitration was to avoid the involvement of domestic courts. Now, what about protection by the investor's home state? Diplomatic protection has a centuries-old tradition. States have exercised it in innumerable cases. But diplomatic protection has serious drawbacks from the investor's perspective. Before the home state can exercise diplomatic protection, the investor must exhaust all local remedies in the host state. That can take time and cost a lot of money. Also, the investor must fulfill stringent nationality requirements. Formal possession of nationality may be insufficient if the investor cannot show a genuine social link to the protecting state. Those of you who have studied international law systematically are probably reminded of the Nottebohm case in this context. But most importantly, diplomatic protection is eminently political. The investor has no right to the protection by its home state. The state's intercession is purely discretionary. It depends on domestic as well as on international political factors. An investor who is in good standing with his country's ruling elite has good chances to receive protection. An investor associated with the opposition has little chance. Even more importantly, diplomatic protection depends on the political relations of the two governments. A weak state is unlikely even to try to accuse a powerful country of illegal behavior and make demands on it. In addition, precarious political relations between the two states may get into the way of negotiations about the interests of a particular investor. I remember asking somebody from the Austrian Foreign Office why they don't complain to Hungary about mistreatment of some Austrian investors there. And the answer I got was, for Austria, Hungary is a difficult and important neighboring state. We don't want to jeopardize our good relations with them. That's a good example for this. Even if the home state does pursue the investor's interests diplomatically, once the state has taken over, the investor loses all control over its claim. The home state may discontinue its effort at any time. It may settle for a reduced amount, or it may waive the claim of its national altogether. The investor has no resort against its home state and no claim for poor representation. Investment arbitration was designed to replace diplomatic protection by the home state and to introduce a system whereby the investor would be empowered to pursue its interest independently through international proceedings. Therefore, from the investor's perspective, there is no real alternative to arbitration with the host state. Neither domestic courts nor diplomatic protection offers an effective remedy. As of late, there has been a curious development which runs counter to the original idea of diplomatic protection. States that had repeatedly seen themselves as the actual or potential targets of investment claims have shifted their loyalty from their own nationals to other states. Not only have states stopped supporting the activities of their investors abroad, on the contrary, they now often actively side with foreign host states against the interests of their own investors. This means that states seek to influence decisions of investment tribunals in favor of respondent states and to the detriment of their own nationals. An early case was in 2001 in the NAFTA framework. There, the Free Trade Commission, a body composed of the 3 member states, issued a binding interpretation which gave a restrictive interpretation of investor rights under the concepts of fair and equitable treatment and full protection and security. Recently, it has become a common practice for non-disputing treaty parties to intervene in investor-state arbitrations. In fact, many treaties, especially those of the United States and of Canada, provide for submissions of the non-disputing states parties to these treaties on matters of their interpretation in pending arbitrations. What is remarkable about these interventions is that, as far as I can see, the intervening states routinely argue in favor of the respondent states and against their own nationals. The desire of the states to keep the general danger of international claims under control is stronger than the loyalty towards their own nationals. I have seen quite a few cases in which the US State Department would intervene in proceedings brought by a US investor against a foreign state. In these cases, the US clearly supported the position of the foreign state against the US national. In a currently pending case between a Canadian province acting as an investor and the United States, I have seen the Canadian central government acting as non-disputing party argue in favor of the United States and against its own province. So much for the relationship between the Canadian central government and its provinces. Other countries, including European states, have also taken up this practice and have intervened in investment arbitrations to the detriment of their own nationals. The argument of states before investment tribunals, either in their own defense or on behalf of other states, have led to an interesting question of treaty interpretation. The Vienna Convention on the Law of Treaties provides that subsequent agreements and subsequent practice of the contracting parties should be taken into account when interpreting a treaty. Respondent states have argued that concurring submissions by states in the pending as well as in other proceedings were such agreements or practice and should be respected by the tribunals. So far, tribunals have mostly refused to accept that argument. They held that arguments in ongoing proceedings were driven primarily by a desire to influence the outcome of the particular case and did not necessarily reflect an agreement on the interpretation of a treaty provision. But these developments show that the tide has changed in disfavor of investors. Nowadays, states seem to be more interested in containing the inconvenience of investment arbitration than in assisting their investors to achieve justice. Let me now turn to the host state's interest in development. The desire to promote economic development is at the historical origin of investment arbitration. Political risk is a powerful deterrent to investment, especially in developing countries. The idea of investment protection is to promote foreign investment through the creation of an attractive climate, an attractive investment climate. Legal security is an important element of that climate. Access to a method of impartial dispute settlement is an important part of that legal security. Now, this is not new. In fact, many investment treaties refer to international development as their primary goal. But most bilateral investment treaties, BITs, in their preambles refer to the aim of economic development. The most important document for investment arbitration, the ICSID Convention, was drafted and is administered by the World Bank, which after all is a development agency. And the first paragraph of the ICSID Convention's preamble refers to, and I quote, the need for international cooperation for economic development and the role of private international investment therein. In one of the first ICSID cases, this was long time ago, decades ago, AMCO versus Indonesia, the tribunal explained that ICSID arbitration is in the interest not only of investors, but also of host states. And it concluded, and I quote, the convention is aimed to protect to the same extent and with the same vigor the investor and the host state, not forgetting that to protect investments is to protect the general interest of development and of developing countries. So the aspiration towards development is clearly there. But are these ambitions supported by hard facts, or is all this no more than wishful thinking? The large number of countries that have ratified the ICSID Convention, currently 158, and the numerous bilateral and multilateral treaties offering consent to investment arbitration would indicate that most countries believe in its beneficial effects. This is clear evidence of a widespread conviction that investment protection in general, investment arbitration in particular, are beneficial to economic development. So is it plausible that all these countries, as well as the World Bank, are victims to a collective mistake? There are many empirical studies examining whether investment protection treaties have an influence on investment flows. In fact, there are books and books about that. Perhaps not surprisingly, the outcome of these studies is contradictory. Some economists tell us they can identify a beneficial effect on investment treaties on investment flows. Others tell us they cannot. Even those who come up with a negative result usually do not assert that there is no such effect, only that they cannot prove it. In other words, even according to the skeptics, the effects cannot be measured, but may well be there. A possible problem with the econometrics of investment treaties is that the economists who undertake these studies do not always measure the right thing. What is protected by investment treaties and what is being measured in these studies is often not the same. Typically, these studies measure capital flows for foreign direct investments, but capital is merely one element of protected investments. The definition of investment in BITs illustrate the range of protected assets and that may contribute to the development of host states. They include intangibles, know-how, technology, and so forth. So a foreign investor can set up an enterprise that uses and transfers technology and know-how with locally raised capital. This investment would be protected by a bilateral investment treaty, but it would not show up in economic statistics that measure international capital flows. In addition, foreign investment is often not a simple bilateral transaction. The counting of capital flows may be distorted by the use of intermediate entities in different countries. In the statistics, the last transit country, but not the country of the capital's ultimate origin, is likely to show up. This phenomenon is made even more complex by shareholder protection. Investment through shareholding in a company registered in a third country is not usually recorded in the statistics, but it may well be protected by a bilateral investment treaties. An OECD study of 2018 came to the conclusion that in view of the multiple and serious methodological shortcomings of econometric analysis, it appears impossible to conclude whether or not investment protection promotes international development. A country's attractiveness for foreign investment depends on a number of factors. They include a good infrastructure, the availability of a skilled workforce, access to raw materials, and market access. Legal security is one element among these factors, but it is not the only one. It is only one part, although an important one, of the spectrum that determines investment decisions. In complex situations and processes governed by multiple factors, it is difficult to isolate particular causes for outcomes. Every investment decision is based on a list of parameters that may vary from case to case. Only an unsophisticated international investor would rush into an investment without looking at the existence and substance of an investment protection treaty on which it may rely. To what extent that aspect is determinative for the investment decision is extremely difficult to tell. Empirical experience suggests that investors preparing for major investment and doing their due diligence examine the treaty framework under which they would be operating. The growing incidence of nationality planning or treaty shopping also suggests that investors do pay attention to the existence of treaty protection before making investments. Public discussions about development almost invariably focus on public development aid programs, bilateral or multilateral. The primary issue is the availability of funds from public budgets. These discussions typically ignore the potential impact of private investments on development. This is all the more surprising since in quantitative terms, publicly funded development aid is very small compared to private investment. The resources available and actually invested in the private sector dwarf the scarce funds that states can mobilize. The real problem in international investment is that for the major part, the huge flow of investments do not go where they are needed most. Finally, there are voices that question the benefits of investment for development and the benefits of development for human welfare. The point may be illustrated by a short anecdote. Years ago, I attended a talk given by an anthropologist who repeatedly traveled to some remote parts of Africa. He told the audience about interesting traditional rituals that members of a particular tribe would practice to fight diseases that were often lethal. When he returned to the area 10 years later, he was dismayed to see that the traditional rituals had disappeared. What had happened? It turned out that with the arrival of modern medicine, antibiotics had eradicated the diseases. From the anthropologist's perspective, this was a deplorable destruction of traditional culture. The story goes to show that perspectives on development and progress can be highly subjective. Finally, let me say a few words about dispute management and conflict avoidance. Earlier on, I spoke about the limited usefulness for investors of diplomatic protection by their home states. Investment arbitration not only improves the investor's procedural independence, but it also relieves the investor's home state of the often cumbersome and politically undesirable task of pursuing claims on behalf of its own investors against foreign states. Investment arbitration contributes to international stability by depoliticizing disputes. It keeps disputes away from the political arena, relieves diplomatic relations, and forestalls potentially dangerous conflicts between states. Diplomatic protection bears a number of disadvantages for the states concerned. From the protecting states' perspectives, the espousal of a national's claim is often a burden to its foreign relations. Sometimes national politics compel the government to lend its arms to an influential client. Democratic governments may be unable to resist domestic pressure to exercise diplomatic protection, even if this is against their foreign policy interests. The state that is the target of the intercession is in an even less enviable position. It is exposed to pressure, possibly threats and sanctions. National pride will soon come into play, and domestic politics may well make it impossible to back down. The inevitable consequence is that the dispute will escalate. Unilateral determination of rights and the relative strength of the opponents govern these disputes. Politics, rather than the rule of law, determines their outcome. At worst, the dispute may develop into an international armed conflict. This is not a far-fetched proposition. There was a time when investment disputes would frequently lead to fierce confrontations between home states and host states of investors. In the late 19th and early 20th centuries, there were numerous military interventions, often by European states, against Latin American countries. Diplomatic protection often led to gunboat diplomacy. Even in the second half of the 20th century, investment disputes have caused armed confrontations. In 1956, the nationalization of the Suez Canal led to a military invasion of Egypt by the United Kingdom and France. The Soviet Union threatened to intervene on Egypt's side, and the crisis was eventually averted with the help of resolutions of the UN Security Council and the General Assembly. Perhaps even more dramatic, after the Cuban Revolution in 1959, the new regime proceeded to expropriate US investments. The US reacted first with a crippling trade embargo. A US-sponsored invasion in the Bay of Pigs in 1961 failed. And in October 1962, this confrontation led to the Cuba Missile Crisis, pitting the Soviet Union against the United States. What was originally a dispute over the expropriation of foreign investments had brought the world close to nuclear war between the two superpowers. There are more historical events illustrating the dangerous potential of investment disputes, but these examples suffice to make the point that before the widespread introduction of investment arbitration, violence was a common element in investment disputes. Today, this is no longer the case. Of course, it is difficult to prove that investment arbitration has avoided armed conflicts. There is no way to demonstrate why military conflict did not take place. As all lawyers know, negative proof is usually difficult, if not impossible. However, it is possible to say that the number of conflicts between states in the context of investment disputes has decreased substantially. Even without the threat of violence, investment arbitration is clearly preferable to political confrontation. For a host state, being sued by an investor and having to pay damages is a lesser evil than being put under pressure by a powerful country or losing the support of a potent supporter. Agreeing to investment arbitration means removing a potentially dangerous dispute from the political arena and transferring it to a judicial forum that applies objective, previously agreed standards in a pre-formulated settlement process. Therefore, investment arbitration is beneficial for three reasons. It provides much needed protection for investors. It has the potential to mobilize private resources for economic development, and it relieves international relations by shifting investment disputes from the political to the judicial arena. Let me make just a brief final remark. Despite the obvious advantages of investment arbitration, there is clearly a backlash against it, both in parts of public opinion as well as in state practice. Investment arbitration, in a way, has been remarkably successful, but to some extent, it may have become a victim of its own success. In the last few decades, there have been hundreds of claims against states. ICSID alone has over time registered more than 1,000 cases. By no means did the claimants prevail in all of them. Many claims failed on jurisdiction or on the merits, but those in which investors were successful were sometimes spectacular and often embarrassing for the states concerned. Consequently, the desire to avoid being sued by an international arbitral tribunal before an international arbitral tribunal and being found in breach of international obligations has become stronger than the wish to see one's investors protected abroad. This trend has manifested itself in several ways. Many investment treaties have drastically curtailed the access of investors to international arbitration. If you compare the NAFTA to the USMCA, or CUSMA as the Canadians call it, that replaced it in 2020, you see that access to arbitration for investors from the three countries has been dramatically reduced. Under the USMCA, there is no investment arbitration between Canada and the US, nor between Canada, and Mexico. Between the US and Mexico, the possibility for investors to go to arbitration remains, but it is now much more restricted than before. In Europe, developments are perhaps even more dramatic. The European Court has decided that intra-EU investment arbitration, that is, arbitration of an EU member state against another EU member state, is impermissible. Under pressure from the European Commission, member states of the European Union have terminated the bilateral investment treaties that previously gave EU nationals access to investment arbitration against other EU member states. There's a broad trend towards restricting investor rights in new treaties. Both substantive and procedural rights are reformulated to limit the possibilities for investors to go to arbitration and to reduce their chances to win if they do. These new treaties are usually presented as modernized versions. In reality, they mean less protection and the reduced chance to get redress. This applies both to bilateral treaties and to multilateral treaties. The modernized version of the Energy Charter Treaty is a good example. One cannot help the impression that the aim of these reforms is to keep up the appearance of international legal protection for investments, but at the same time deprive it of much of its substance. Now, I hate to close my remarks on this rather pessimistic note. It is entirely possible, and I hope that at some point in the future, the pendulum will swing back and the recognition will prevail that the international protection of investments, including through investment arbitration, is to everybody's benefit. Thank you very much.